This is a case that we handled for a North Fulton cyclist who was riding one Sunday afternoon and got hit by a car straight on from behind. It should have been clear liability, 100% this driver's fault, 0% on the cyclist. As you'll hear, it got a little bit more complicated as things went on. The cyclist, by the way, was doing everything right. He couldn't have been more proper in his riding. This is a guy who knows how to ride a bike. He was brightly colored top to bottom. He was visible in the lane to most normal drivers, but he was not visible to this driver. Now, why is that? It's for a couple of reasons. Number one, the driver was following the car in front of him too closely. He claims that the car in front of him swerved out of the lane very suddenly, and at that moment, he was confronted with this bicyclist directly in front of him and couldn't avoid hitting him from behind. The story didn't make sense to me, and I didn't buy it. I didn't believe it. We ended up in litigation on this one because the insurance company would not treat our injured client fairly. They offered him some money, but it certainly was nowhere near enough for what he went through with his injuries. So we started digging in on who this driver was and what was really going on. And it turns out through our investigation and through the things we were able to uncover in the driver's medical records, we came to find out that this driver had a not necessarily a lifelong vision problem, but he had such a terrible vision problem that years before this crash ever happened, he had been told that it was unsafe for him to drive a car and that his vision was so bad he could not legally satisfy Georgia's minimum requirements for vision to be able to get a license and drive your car. And he was supposed to wear some sort of a bioptic telescopic lens on his glasses, which was probably about this thick and attached to his glasses for him to be able to drive a car. Well, this guy just thought that was inconvenient and he chose not to do it. So here he is driving essentially blindly, failing to meet even Georgia's minimum standards, but claiming that he couldn't see the bike in front of him who just popped out of nowhere and appeared too suddenly for him to avoid. So this struck us as a very clear liability case with a driver who should not have been driving in the first place, which we only found out through our digging through the medical records line by line and just following our instincts, which were something's not right about this guy's story, and we figured out what it was. We took this case to a focus group, and by that what I mean is we took the facts of this case and presented it to just 12 ordinary people that showed up to hear what the case was about and kind of give their opinions. They act as like a mock jury. It's really helpful to us in the larger cases to kind of shape the arguments, get an idea of what people think about. Sometimes as lawyers, we can't help ourselves. I get too close to the case to be completely objective about what the evidence is. And so you hear it from 12 strangers who've never seen this before, don't know the client, don't know anybody, and you start to pick up on some different things about it. It was amazing to me how none of these people on our mock jury put 100% fault on the part of this driver, despite everything. They still wanted to put some blame on the cyclist. Some blame the cyclist for everything, essentially saying you shouldn't be on the road on a bike. This is important information for us to know and understand people's attitudes, because we know that if we ever do go to trial, which is our ultimate leverage on the case, these are examples of the type of people who show up for jury service and who we have to persuade in order to win our case. So it was helpful to go through this exercise, even if I didn't like what the mock jurors on our focus group had to say, because it helped us to shape our case and helped us recognize where the risks were to us. Ultimately, the facts we uncovered about this driver's vision issues, combined with our client's stellar record and certainly the seriousness of his injury, helped us to get him a great recovery. Everybody was just pleased as could be with the way it turned out. And as much as I would love to have had this guy on a jury to cross-examine him about his vision and his failure to wear that safety device, the reality is that's an exercise in ego. We're not here to build up my ego. We're here to get good results for our clients and try to put them in the best position possible. Sometimes that means taking a case all the way through to trial. More often it means getting them the best settlement that we can get them and something that removes all risk for them and gets them made whole for what they've been through. That's what we did here. And it was really the result of a great client, but also some great legal work on the part of our whole team over here at Hagen Roscoff.